thank you, Taxmann, for giving me this platform to present my thoughts on reverse flip. So, with no delay, just starting on to you know, so in today's session, what we would be covering is, just a quick overview that what is reverse flipping, what is the genesis of the reverse flipping, why did the companies at the first place move to the foreign country, right? And then what's prompting them to come back to India, and then a short summary on that, what are the successful reverse flips so far, what are the case studies around that, and then few structures as to how to implement the reverse flipping, for the companies who are looking to go that route. And then at the end it would be followed by a Q&A session where I'd be happy to take forward all the questions that the audience might have. So now, like I said, what is reverse flipping? Okay, so the structure that you see at the extreme left is like the basic structure wherein, as of today, there's an Indian company and that could have investors, shareholders, and that's a clean structure, right? Now, what happened, almost a decade ago, or, due to various reasons, which I'm going to cover in the next slide, you know, the shareholder essentially incorporated a overseas holding company or essentially moved to a overseas location such as preferred was US or Singapore, and then and from that country essentially operated or set up an Indian company to operate their operations, right? And now what's happening that the trend of or the process of essentially eliminating the overseas company, right? Wherein the founders or the investor or the shareholders of the overseas company would hold the shares of this Indian company directly. That process is called a reverse flip process, okay, or an internalized structure. Now, just moving on to the reasons that why at the first place the company moved their base to overseas countries, right? So if I recall my discussion with my clients, during the early, and this is almost like a decade, right, when this process initially started, right? So one of the major push to, to have their headquartered company in an overseas jurisdiction was the ask of the investors. Okay, and I distinctly remember that some of the Y Combinator companies, there was a specific conditions which tells them that in order for them to fund, essentially it's important to be a foreign company or to have their the parent company in either US or Singapore, right? They were not okay to invest into any other jurisdictions, right? So that was so the major point was the push from the investors side, right, to have a overseas cooperation. And there were the multiple other reasons as well, right? Such as most of this company, like we know, it's into the tech sector, right, wherein tech is the base, and US being the the buyer of all techs, right? It's the largest economy, right? So therefore having a overseas headquartered company essentially, it kind of provided them the brand name that okay, it's a global headquartered company. It's easier to onboard new customers or overseas customers, right? And so those were few of the reasons why the company at the first place moved to the overseas country, right? And then at that point of time, the IP protection laws were not so strong in India, right, as compared to overseas, right? And like in this tech companies, essentially the major the value of the company was derived from the IP, right? And hence having a stringent the IP protection laws was something very important for the investors to invest, right? So that's also one of the important reasons that why companies used to set up their parent company overall, right? And then while if you see over a past, like I said, okay, this all started past decade, right? So India was not so favored in terms of the regulations. There were a lot of restrictions, for the investor to invest in terms of means the sectors it can invest, in terms of round tripping concerns, right? Whereas in overseas, essentially, it was much more simpler and easier regulations, less regulations as compared to what was there in India. So it was like a quick play for the company to get started, right? So that also was one of the reasons, right? And other reasons were definitely the tax optimization, right? So essentially, if the investor had to invest into India, then they have to pay taxes in India as well, right? And then definitely they might get credit in their overseas countries, but at that point of time, tax reasons were also one of the reasons that why investor wanted them to set up a parent company in jurisdiction like US or Singapore, right? And ultimately, like, what's the whole purpose of doing all this, right? It's exit, right? And essentially most of these tech companies, like I said, the buyer at that point of time was, you know thought from an investor or from a founder perspective that they are ultimately going to be acquired by US companies. And definitely, being a US headquartered company helped them, enrich a good valuation in terms of multiples, right? And also, in terms of overseas listing. And this is again the story, a decade back, right? And that's where these were some of the reasons essentially that why company moved out of India at the first place, right? Now, why companies now again who has moved back almost a decade back or over a period of time, then why they are preferring. The reason is very obvious. The number speaks for itself. India, around a decade back, it used to be like the 11th largest economy, whereas now today it's the fifth largest economy. It's growing at one of the fastest, like the last numbers were around growing at a rate of 8.2%, right, which is the highest among all the major economies, right? But again, they were like, like I said, key in the past, the major reasons were the investors pushed to set up a company in the overseas jurisdiction. And now, given the reforms that India has undertaken, to make it an investor friendly environment, right? And that's one of the key reasons, why companies are choosing to return to India or why people are thinking to move to India, right? And to take a few examples in terms of tax incentives, definitely one of the key thing being the rationalization of the corporate tax rate, right? Now the tax rate earlier, which used to go up to 35%, is as low as 15% and is competitive with the with many developed countries like US or Singapore, right? Or at least the comparable. US is at 21 and Singapore being at 17, right? And then there are other incentive as well, like the startup, the exemptions provided to the startup in terms of taxation, abolition of angel tax, rationalization of the capital gains tax rate, which was brought in the last budget. And there were many other tax incentives that have been provided to make it like an investor friendly jurisdiction, right? And then over a period of time, there were a lot of FDI relaxations have also been bought, right? And my LinkedIn was flooded with the last FDI relaxation in terms of not the FDI but the company relaxation in terms of wherein uh, a 233 or a fast track merger is being available for companies located or established overseas India, right? And then there are other incentives also to set up their operations in India, like Make in India, in terms of PLI, other incentives, right? And then spending few more minutes on the key points in this slide, which is essentially the IPOs, right? So if you see the major of the names that at least available on the public domain is essentially the unicorns, right? And essentially they are planning to move to India as they see their exit through IPO, and India market is booming in terms of IPO, right? So just moving ahead of what are the flip stories so far. So one is essentially PhonePe was one of the first companies to undertake the reverse flip, which came at a very significant cost of $1 billion, right? And to the extent of the information that's there in the public domain, the structure was something like this: that PhonePe India had a PhonePe Singapore parent, and then PhonePe Singapore parent essentially transferred the shares of PhonePe India to the shareholder of PhonePe Singapore, right? And then essentially whatever proceeds PhonePe Singapore received, they distributed by way of a dividend to its shareholder, right? And now the leg essentially wherein PhonePe Singapore transferred the shares of the phone pay India to to its shareholders, that was the leg that caused Singapore, that caused phone pay essentially to pay a huge amount of tax, right? While definitely under the Singapore Treaty, prior to 2017, there was an exemption that's there, but post 2017, since that exemption was not there, and hence the leakage. Right? And now, since we are at Singapore, I just wanted to, point out two more important development that has happened post, essentially post the phone pay transaction. One is essentially the introduction of the 10L in Singapore, tax laws, right? Which essentially provides that if a Singapore company is earning any, so currently the position is that Singapore does not levy capital gains tax, right? And because of that reasons, many companies were incorporated in Singapore just to take advantage of this position, right? Because Singapore domestic tax laws does not levy capital gains tax. Now, post introduction of 10L, what has been proposed is that you know any income that is received by a Singapore company through the sale of a foreign asset, okay, and received in Singapore, it's a keyword there, by a relevant entity, which means an entity which does not have substance in its forms, then that such income could be taxed in Singapore. Of course, this is subject to various conditions, but essentially the essence is the company lacking substance and just incorporated like a post hoc companies in Singapore now have to pay capital gains tax in Singapore as well, right? So that's one of the important development that happened from a Singapore perspective. And another important thing that's happened in Singapore is the introduction of the merger regime. So under the Singapore tax, under Singapore corporate law, there's no specific provision or used to be a specific provision governing a merger of or essentially allowing a outbound merger, right? But in the beginning of the 2024, we saw Pine Lab securing or being one of the first to obtain the order for this inbound merger, outbound merger from a Singapore perspective. Although the India leg is still pending, but it sets a strong precedence in terms of merger be outbound merger being there in Singapore, right? And that could help many other companies who are currently headquartered in Singapore, right? Now, moving on to the next one was grow. Essentially, it was the second one to do a flip, and here although the numbers are not there, but essentially the way this grow merger was done was one of the tax efficient manner, at least from an India tax perspective, which is essentially an inbound merger. While I will cover as a separate case studies as to how what are the steps involved in the inbound merger and what are the tax India tax consequences, at least for a domestic merger. But yeah, that's the merger is essentially one of the tax efficient or the most tax efficient way in which a reverse flip can be done, at least in India today. And then one of the other example is definitely Pepperfry, which again completed its inbound merger through by way of a merger process. Okay, and again, from a US perspective, I just want to bring one important point. Like I said, while from an India tax perspective, it's one of the most tax efficient way to do a reverse flip. But definitely, you also need to check the laws of the country, right? Which is essentially the US, wherein the parent company is incorporated. Now in US, although there is a specific provision for outbound merger, right? But there is also a concept called like a anti-inversion rules in corporate anti-inversion rules in US, right? Which essentially prohibits US based companies to avoid tax to prohibits US based companies to avoid tax by shifting to a low tax jurisdiction. So essentially, it means that if a US headquartered company, right, is moving its headquarter by way of a merger or acquisition to any other company, which results in shift of all of its assets from US to any other country, then there is something, a tax is there, something called a exit tax in US, right? Again, that is subject to various conditions. There are various relaxations also available, 80% inversion, 60% inversion. Since those are specific to US, I'll not be focusing on that. But this was just to give a flavor of what you should be also mindful of if you are based out of US, right? And now essentially the second box list out the names which are there in the public domain, which are currently in the process of flip, and they are evaluating what's the press structure, from a tax and definitely from operations perspective to do the flip. So before moving on to the structure, right? While definitely there are a couple of structures which are being implemented and have been implemented for doing the flip, right? But before going into the structure, it's very important to the basis by which you will choose the option depends upon various of factors, right? Like some of them being that what are the sectors of operation, correct? So and this being, let's assume FDI is prohibited in certain sectors in terms of all certain sectors, or essentially there are some guidelines to be followed, correct? So therefore it's important to understand that what is the sector, right? What stage of business, right? While in public domain, it's all the names that's there is either a unicorn or looking for a exit through IPO, right? But it's also important for early age startup to to understand that whether this is the need for our, and again, sole reason being given the the reasons. Now India is one of the preferred destination for investments as well, right? In terms of, like, there's no need, means enough of India capital is also available in for the expansion, right? Which was not the case a decade back, correct? So again, then definitely, like I said, the stage of business, what are the sector of operations, and then the next is, like I said, key, what are the overseas tax and legal consideration, right? If depending upon an overseas tax and consideration for the shareholders as well as for the overseas company. Again, what are the India tax and consideration? And then the most important part is that how the option, or what is non-negotiable for the business, right? Because choosing any of the option could be a complex one and could disrupt their business model as well their operations, right? So therefore having thinking all of these factors, essentially the option needs to be chosen, right? Uh, so basically, I'm going to discuss, this five options essentially, and primarily what I would be covering is uh, primarily the tax implication, means the key mechanics, how this option would work, and the key India tax implications for such structure, right? I'm not covering the US tax or the overseas tax implication, because again that depends upon jurisdiction of those companies and very fact specific, right? So while these are few options that I'm discussing, but in a specific case, it could be a mixture of any of the combination, or there could be the other options as well, right? So just moving ahead. Yeah. So the first option that we are considering is, for early stage companies, right? So basically, for early stage companies, like I said, who have just started their operations, or there are insignificant amount of operations there, they have not raised the funds, right? And still contemplating that, for, like, n number of reasons, that if we should move to a structure in India, right? Then a simple process or the simple option could for them would be to 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 set up a new structure altogether for undertaking the business, right? And let's assume if there are any asset which definitely needs to be or which definitely needs to be moved to the new structure, then essentially that could be done by way of a slum sale, right? So here essentially two flavored option for this new structure. One is like, you close everything what's happening in the old structure and then set up a new structure, right? Wherein essentially the shareholder will set up a new India company, and then if required the new India company can set up a new overseas companies as well, right? The only important point to ponder is that, if you need to transfer the asset from your existing company to the new companies, then definitely it can be by way of a slum sale or asset sale, depending upon what type of asset, what the nature of business is, right? And depending upon the fair market value, and given that this could be a related party transaction, so transfer pricing provisions may also be applicable in this case, right? And hence, depending upon the options that you choose, there could be a capital gains tax for the transferor company, right? And also important point to note is that given that you're starting afresh in this new company, right? So therefore, whatever losses, if there is any in the existing structure, would lapse, and there's also a pain of winding up the existing companies. uh, yeah, so that's on this structure, and this is one of the quickest to implement, right? But like I said, this is only could work. The structure could work in case of very early stage companies who are yet to raise funds or have raised nominal funds from angel investors or something like that, right? Now, the other prevalent structure that's there is essentially, is the liquidation of overseas company. Okay. In this, and again, it depends upon whether liquidation is permitted in the jurisdiction where the overseas holdco is located. Now, in this structure, what happens? Overseas company, pursuant to liquidation, distribute the shares of the India company to its shareholder. Okay. Keeping aside the tax implication in the overseas company jurisdiction on distribution of shares of the India company. From an India tax perspective, there's a specific exemption under 46(2) in relation to distribution of asset pursuant to liquidation by the overseas holdco, which is essentially this leg. And what 46(1) 46(1) provide for the exemption, and 46(2) essentially provides the taxability in the hands of the shareholder, right? Now in the hands of shareholder, what the essentially the provision provides that to the extent of the accumulated profits of the holdco, essentially it would be treated as a deemed dividend for the shareholders, and any amount received in excess of that or the fair market value of those shares, less the cost of acquisition, it would be treated as a income for the shareholders, right? So this is there, and now given that from an India tax perspective, it essentially could also be treated like a indirect transfer, right? Because essentially shareholder is transferring the shares of overseas holdco, so the indirect transfer tax implications could also be there in this situation, right? And also now, with demat coming into picture mandatorily for certain class of Indian companies, right? And let's assume if pursuant to that, if once take a position that the demat, because of, and the shareholder or the overseas shareholder also need to have a demat account in India. So essentially, pursuant to liquidation, what's happening that the shares which are in demat, and the owner is overseas holdco, it's being transferred to the demat account of the shareholders, right? So in such case, it could, even one need not go into deemed to accrue or rise in India like indirect transfer. It could also be treated as a receipt of shares in India, right? And therefore you don't have to test the indirect transfer tax provision, but again, it's treated as a receipt in India and hence taxable, right? So that's also one thing that's there. And definitely, this is the taxation under the Indian tax laws, right? And definitely the shareholders are eligible for some treaty benefits, and definitely that would prevail subject to satisfaction of the conditions that require to claim the treaty benefits, right? Now, like I said, the disadvantage of this option is definitely if there is no treaty benefit, there's a tax leakage in the hands of shareholder pursuant to the receipt of shares of India company, because there's a change of shareholding of India company, right? So if there are any accumulated losses at the India company level, such losses will also lapse, right? That's the other thing. The third disadvantage is essentially the reset of period of holding and the cost of acquisition for the shareholders, right? Because this is treated like a transfer under the Indian tax laws. And then there could be other operational challenges which you may have to figure out before doing a liquidation, right? Which is essentially, let's assume if this overseas holdco is holding IP, right? And that IP is essential to run the business of that India company, right? Now how do you because if you do a straight away liquidation of the overseas holdco, then even the IP along with the shares of the India company would move to shareholders, right? So therefore, some structuring may be required to move the IP to India, or something, or move the IP to India before doing this liquidation, correct? There could be and this is the point that I'm going to mention. It's applicable for pretty much all the structures in terms of the ESOP reset period, right? So what would have happened in the existing structure is that the overseas holdco would have issued ESOPs to the shareholders of the India company, right? And now, pursuant to this flip that's happening, India company may have to float its own ESOP policy again, and therefore, under the Indian corporate laws, there is a minimum vesting period of 1 year that's there, right? So that's again something the ESOP holder have to comply with. So those are the small small things, but this is how broadly this structure would work in case of liquidation. So in this option, this is essentially again not a very tax friendly option, but like I said, depending upon the objectives of the overseas holdco, right? This is one of the quickest option in terms of to implement, right? Which is essentially transfer of shares, and similar to something is what happened in case of a phone pay scenario as well. Okay. So here, essentially, what happens is that overseas holdco will transfer shares held in the Indian company to the shareholder. Okay. So in that leg, essentially, there would be tax. Whatever is the fair market value of the asset less the cost of acquisition, that be tax in the hands of overseas holdco. And now, the consideration is outstanding for the shareholders. Essentially, the shareholder has to pay the consideration for them, for the shares that they have acquired. Okay. And because of the profit that has arisen from the sale of shares of the India co, this overseas holdco will essentially declare dividend, right? And whatever is the dividend gets declared, right? It gets offset against the consideration that was receivable from the shareholders, right? Or the other way also could be to do a liquidation, or a cap reduction of the overseas holdco, and whatever is the consideration payable against the cap reduction, that gets settled against the consideration receivable from the shareholders. Okay. uh, yeah. And again, similar to what we discussed in case of the liquidation option, right? There also, here also lies the challenge of the lapse of the business loss of India company, right? Because there's a change in shareholding of the overseas company, and again the same ESOP challenge also remains. Okay. The only advantage of this option is that both India company and overseas company can continue to continues to be there. right? It result in some kind of split valuation for the shareholders, right? And which, if required, the overseas companies can again be liquidated because it does not have anything. uh, and this is one of the quickest one to implement technically, and this is in a kind or a flavor of what happened in case of a phone pay scenario as well. So, moving to the next option of swap of shares. Okay. So, in this option, essentially, it's a flavor thing of the liquidation that we discussed, right? But essentially, it's by way of a swap. So, here, what happens is uh, the shareholders would set up a new India company, which will in which essentially they will mirror their shareholding. Okay. And then as a next step, what happens that the shareholder would essentially transfer the shares of overseas holdco to this new co. Okay. And this new co essentially as a consideration, would issue its own shares to the shareholders. Okay. Again, just to reiterate the step one, essentially shareholder sets up a new India co. Okay. Shareholders transfer the share of this overseas holdco to this new India co, and this new India co discharge the consideration for acquisition of shares of this holdco by way of issue its own shares. Okay. So the resultant structure will look something like this. Okay. Now, before coming to the tax, briefly touching on the FEMA angle of it, right? So recently, in the early 24, what was the kind of swap that was permitted under the FEMA regulations were that, it allowed Indian company to issue its own share against a swap, but that swap could be only of the shares of an India company. Okay, so basically, if there is a shareholder who is holding shares of another Indian company, then that shareholder could have transferred the shares of the Indian company to this company, and this company would have issued its own shares as a consideration. Okay, but the ODI FDI swap was something not expressly permitted under the FDI regulations, and it required a, RBI approval for that. Right, if you have to do this kind of swap. So again, this is again a welcome step, and to promote inbound mergers, right? So that is something there under the FEMA thing, and now. Yeah, and now coming to the India tax implications. Okay, again, it's similar to, like I said, in case of liquidation, how it triggers the indirect transfer implications. Right now, here it will be a straightaway applicable of that, because so on transfer of shares of overseas holdco, essentially there could be indirect transfer tax implications in the hands of shareholder if the value of overseas holdco is substantially derived from the assets of India. Uh, that's one of them. Uh, yeah, and like I said, if the need being, then we liquidate, and I think we briefly touched upon the implications on liquidation of the overseas holdco in the earlier slide, right? And this also results in same kind of disadvantage in terms of losing out the so here only one advantage if you see comparatively to the other structure. Now, if you intend to hold the overseas company, then essentially because there is no immediate change in shareholding of the India company, the losses of this India company lapse would continue. But given that the intent of this flip would be to make it a India headquartered company, so at some point of time you have to liquidate this overseas holdco so that it's a complete India structure, and hence again the losses would lapse. Uh, Moving on to the last option in terms of, I think we are moving little fast. So Shiv, should we ask some questions before proceeding, or should we continue to close this, because I don't have much slides post this? I think Shiv is not there, so I think we can continue, right? So I think this is the option of the inbound merger, right? Which essentially is like what Grow has opted for, which is essentially merger of the overseas holdco into India company, and then India company issues its own share as a consideration, as a discharge of consideration for acquisition of shares of this holdco to the shareholders. Okay. Now talking about few regulations, right? Starting from Companies Act, right? So under the Companies Act in 2017, essentially, 2017 233 was 234 of the Companies Act was made effective to permit inbound and outbound merger, and subject to, of course, satisfaction of certain conditions. And then recently, like I was mentioning a few days back, what the government also allowed for is that if the overseas holdco is the holding company and the India company is a subsidiary of the overseas holdco, then earlier what was allowed was that this overseas holdco has to go under the NCLT route, right? Which is a lengthier process and which takes like anywhere between 9 to 12 months to complete the merger, right? But now a relaxation has been provided wherein overseas, the India company can go to the register of director under section 233 of the Companies Act, which is called a fast track merger. The compliances involved, the timelines involved is very less as compared to the NCLT route. Okay. So that's something that's been permitted. So now the NCLT merger, which could earlier would have taken like somewhere between 9 to 12 months, now could be if the prescribed conditions in terms of what is prescribed under 233 of the Companies Act, is met, then this could be done in like 5 to 6 months as well, right? But one of the important conditions, that's mentioned under the new regulations which allowed, merger for 233, is that, a prior approval of RBI would be required for both holding company and the India company. Okay. So earlier, the requirement to take approval means, when I say earlier, essentially when you were allowed to go to, when the merger was there under section 230, 232, which is, let's assume, call it like a NCLT route. So under the NCLT route also, there was a requirement of prior approval of RBI. Okay. However, in the year 2018, essentially, the RBI came up with the FEMA cross-border management regulations, which essentially again laid out the conditions or the regulations for inbound merger, right? Which and subject to the if you are satisfying the conditions which are prescribed under the regulations, and for inbound regulation 4, then technically it was a merger under means, it was deemed to be a deemed RBI approval for the merger, and you don't need to go to specific approval for RBI, right? So just to summarize, right? Earlier, you could have approached the NCLT, okay, and prior approval would have required, but there was a relaxation under the FEMA guidelines to say if the prescribed guidelines for the inbound mergers are satisfied, then it's a deemed approval and you don't need to come to RBI for approval. Okay. And there the timeline was somewhere 9 to 12 months. Now, post amendment, under the Rule 25A, which allows the companies to apply for a fast track merger. Okay. Again, in the fast track merger, similar line in terms of prior approval of RBI is required is there, but post 2018, RBI has not come up with any clarification, because the way the old FEMA regulations are drafted, it says the conditions are saying that subject to the order of NCLT. So the wordings there is used in the regulation is order of NCLT, and it doesn't talk about the RD or the central government, which is currently there under the under the RD route. So hopefully a clarification should be issued by RBI in this perspective, that even in case of a RD merger, if you are satisfying the condition which are prescribed, then you don't need a prior approval of RBI in that case as well, right? So that's a very brief on the company law and the FEMA regulations. And now coming to the income tax regulations, essentially, there's a specific exemption provided under the Income Tax Act, right, for a inbound merger, right? Again, that is subject to satisfaction, and one of the important condition is that it should satisfy the definition of amalgamation, provided under the Income Tax Act, right? And therefore, it becomes important that it is a amalgamation in both the country, essentially a merger in both the country, right? In the country of overseas holdco as well as country of India co as well. Okay. Here the like I said, the benefit is that given that there is a specific exemptions that's available for the overseas holdco in relation to transfer of shares of India co, shareholder on transfer or the extinguishment of shares of overseas holdco, and again receipt of shares of India co, right? So it's a tax neutral event, at least for the three parties in case of an inbound merger. However, again, like I said, in case of US, there is anti-inversion rules because of which exit tax could come, right? So that's one thing we should keep in mind in case of this inbound merger. What are the overseas regulations, right? Whether there is any tax in that country in the event of merger, and the second important point being that whether that merger, first of all, is permitted in that state, right? Because, like I said, in Singapore, there was no concept of a outbound merger, right? And like Pine Lab was one of the first to set up that precedent, right? So those points again, in terms of losses, given that again there is a change in shareholding, the losses would lapse, right? However, there are judicial precedents, which provides that although means although under section 79 says that if there's a change in the immediate shareholding, the loss would lapse, but there are case laws to suggest that if the ultimate beneficiary is the same, then technically the losses can be carried forward. Again, that's subject to interpretations, right? And now the other advantage of this option is that, like I said, in earlier case, people, the shareholders were losing their, the period of holding, right? Which could be one of the important factor in this. The period of holding continues to be with the shareholders. So a brief on this. Okay. Moving to the next piece, essentially, uh, not on the option, right? But like I said, the government is taking wide variety of steps, and in 24 itself we have seen lot of steps taken by the government to promote internalizations, right? And while there is no specific regulation that has come for internalization to gift city, but gift city can be one of the preferred destination for internalization. And there was a committee that was set up specifically to suggest steps in terms of, so that there is no brain drain, essentially how to bring back the Indian headquartered companies from overseas to India, right? Like that's one of the objective of gift city, right? That how to bring from offshore to onshore, right? And the committee has suggested a lot of steps in terms of what can be done in terms of to promote internalization. And we all have seen in the past few budget also that there are so many relaxations, so many incentives being provided in the gift city, to for relocating of the funds. So typically today the tax exemptions are for the funds which are established overseas to relocate it to India, right? But again, what this committee has proposed certain measures. So whatever the drawbacks or the problems that we discussed in each of the earlier options, right? That the disadvantages in the earlier options, like losing the tax losses, right? Losing the period of holding, right? So these are the recommendations by the committee that to promote this internalization. One being that IFCA should be considered as a nodal office or a one-stop solution for this entire process if implemented. The second, and this is again few of the steps that's there. Second is essentially that a tax neutral structure should be there for tax neutral in terms of both the shareholders as well as the overseas holding company who wants to move to India. Again, the other piece is the grandfathering. So let's assume if the overseas company would have continued, right, and the investor would have continued to hold in that overseas company, and let's assume for the time being that he's eligible for treaty protection, and he didn't have to pay any taxes in India, right, on the exit of such investment. So that's a recommendation that whoever are the existing shareholders of the overseas company, there should be grandfathering provided for such shareholders, so that even if they internalize to India post this flip, then there should not be any tax for them, even for the accretion of value, right? And then again, the place of effective management rules, which is essentially the substance related points. The next point we discuss in terms of how to protect the losses. And I think again, the last 2 points is essentially regarding, today we have a limit of 250K for investment in Gift City under the LRS route. So enhancing it to a higher number, to promote the Indian investors, at least the angel investors who are investing in this individual capacity, to invest in the Gift IFSC, right? And recently, we also know that the listing regulations have also been notified for the Gift City, which again stimulus, promote Indian company from flipping essentially, right? So that they can list in the Gift City itself and can raise capital, which was one of the major reasons why they flipped to the other countries. So I think this is it from my side. I've tried to cover in short and crisp to the extent possible, and didn't wanted to make it too boring or too regulation specific. So I can take few question. So one of the questions is that I just wanted to understand that which is the best tax efficient option in view of income tax and FEMA rule. So like I mentioned, again it depends upon, means don't want to look at tax as one of the, although it's one of the key important points, but if you ask from a purely from a tax perspective, then definitely the merger seems to be the best option, the inbound merger, again subject to the the laws and regulations of the overseas countries, right, depending upon which the shareholder is located. There's other question under liquidation option, what is your opinion? So the question is essentially that in the liquidation option, essentially whether you will get cost step up of the India company shares which is being distributed. So again, not very clear, but given that the shareholder would be paying tax on that amount, and hence it should be available. Just 1 second. How does the reverse flip access to global capital market and affect access to global? So the question is, how does a reverse flip affect access to global capital market and foreign investments? So I think, like I said, there are n number of reasons to move to India, right? For the investor, and investors are looking more and more to invest into India, right? So it's no longer the old India wherein uh, we have to go to the investor to invest, right? India is like becoming an investment magnet to attract investments. So I don't see that it's affecting in an adverse manner, but more in a positive context. Sure, I think there are a few more, but I'm not clear on the questions, but happy to take it offline, uh, or over LinkedIn, or please feel free to reach out to me. I think this is it from my side. Thank you all for joining.